All right, welcome back. This is a capsule on the United States case of Obergefell v. Hodges. Obviously, the reason we're reading this case is because we have some very interesting perspective from the United States on the issue of same-sex marriage, which we also saw, of course, in the reference regarding same-sex marriage. The case is much later dated, right? So the reference on same-sex marriage is quite a number of years before. So we see that, right, tide in public opinion changing in Canada perhaps earlier than it did in the United States. There's mention by the Supreme Court of the first laws legalizing same-sex marriage being passed around, I think, 2008 in the United States. However, very, very interesting case. Certainly, if there's one reading in the entire semester that I won't force you to read that you probably should, it would be that one. There's a very, very interesting discussion of fairness, the underlying social issues, and the role of judges in a constitutional democracy. And you'll see three dissenting judges, or four, I think, each writing separately, right? Each are guys. You might think that makes a difference. And having a very, very impassioned defense of the role of courts in a constitutional democracy and saying, even though we might agree with the majority, right? And arguably Chief Justice John Roberts agrees with the majority, right? On the result, says it's not really, they say it's not really the role of courts, right? We're trying to use the Constitution beyond its actual limits. And even though we might agree with the result on one specific issue, right, here same-sex marriage, we all lose in the end because we lose that ability, right, to decide for ourselves, right? We have a government of 9 unelected, unaccountable judges. That's a phrase that's very commonly used by these judges when they're dissenting, who make decisions beyond important social issues. And of course, in the United States, there's a much stronger tradition of liberty. Liberty in the sense of being free from government. You see that, I think, from Justice Alito, right? This tradition of, right, being left alone, and liberty being the ability to do whatever you want. Not needing much government intervention to do that, as we do in Canada under this paradigm of substantive equality under Section 15 of the Canadian Charter, right? Not needing benefits or assistance from the government to get the same access to things as everyone else if you're part of a historically marginalized group. Of course, these things are general principles which don't always find applications, right? Of course, United States constitutional law is not evil, does not completely ignore the plight of minorities, but certainly, right, has a narrower conception of what it is that you can invalidate under the 14th Amendment, which is the Equal Protection Clause, which is the United States analog to our Section 15. And specifically, right, this idea of both equal protection under the law, which is this non-discrimination issue, and the Due Process Clause, which is the court decides on to start with, right? The Due Process Clause, of course, says you can't be deprived of certain things without due process of law. In other words, if we are going to infringe upon your liberty by taking your stuff, or even worse, putting you in a cage, we want to be sure that it's a legitimate reason. It's a result that you will, right, even though it affects you, perhaps be able to agree with, or at least you'll be able to agree with the institution itself that legitimates the government, right, using that brute force to take stuff away from you or put you in jail. It's due process. And generally, the more important what we're taking away from you, right, the deprivation of, right, a right, a liberty, right, the more significant it is, the more due process you will be entitled to, right? So we won't expect some government bureaucrat to sign a piece of paper that says, Mr. Lloyd's going to go to jail, right? It's not sufficient due process given the magnitude of what we're taking away from you. And because there's no clear protection of things like intimacy, right, the freedom to get married, the court has used the Due Process Clause, and I want to be careful in my language here to be somewhat objective, but the court has used, right, the due process protections to recognize that certain things are so significant that they can't be taken away from you regardless of, right, the process that you get. So even with due process, in other words, there never is enough due process. And that's where the court has recognized, right, kind of an irreducible core of liberty or freedom, where, right, the government can't, right, decide what you do in your bedroom, for instance, by criminalizing homosexuality, which is what was done much prior, just prior to the fight for same-sex marriage. The issue is far starker, right? People thought that homosexuality was dangerous, and of course we can have a pretty long discussion on the purpose of criminalizing things. You'll see that in my own article on Quebec Bill 21, right? This idea of criminality, I think, really engages our fears, right? Criminalizing things is the worst thing you can do, generally having to do with putting people in jail. And therefore, we reserve it for the things that we are most afraid of, like murder, right? Like someone raping our kids. It's something that we're really afraid of, and therefore we use the criminal law, which is our starkest tool, and arguably, at least as I argue in my paper, right, we canalize this energy, right, this fear of the other in a way that, right, makes us as a majority feel better. And so the criminal law was used perhaps to channel that fear of, right, the other, and that fear of homosexuality. And so homosexuality, right, was criminalized just years before, right, the first recognitions of same-sex marriage legislatively in the United States through crimes of sodomy, basically, right? So you probably know what sodomy means, right? That was a way to criminalize homosexuality. And so, right, the practice of the intimate relationship between the same-sex couple was criminalized. And in that sense, right, the government can intervene, at least according to how the Due Process Clause has been interpreted. If the government is trying to, right, get into something as intimate and personal as what you do in your bedroom with a tool as stark as a criminal law, then that due process, right, the substantive due process, that these rights that you can't take away regardless of the process are going to be, right, engaged. And interestingly, it's something you can look up on your own. It's also how the right to abortion was eventually constitutionalized in the United States. So here we have, right, an opinion much later than the one in Canada, right, relatively recent. Of course, comes from a tradition in the United States that's very different. I said there's different conception of equality. There's certainly more of a right-leaning majority in the United States on these various issues. And also, there's different constitutional tradition, right? We don't have a charter, right, like we do in Canada. It was passed in 1982 that not only provides for, right, more progressive rights and freedoms than in the United States, like the right to equality, which is defined very specifically and in a way that is far different than other constitutional traditions, but we also add, as I said in an earlier lecture, some canons of interpretation in there. And so we give progressive interpretation to the Constitution, right, in a way that this debate couldn't happen in Canada, right? No one could say or really care what the original meaning of the Constitution was either in 1982 or 1867, right? Because the Constitution, you're told, from 1929, the Persons case, I mentioned it, right? Long time ago, back when the House of Lords was in Great Britain, right back when women probably didn't have a right to vote, much less a right to own property except through their husband, right? The House of Lords said the Constitution is a living tree capable of extending within its natural limits. So this originalism discussion, which is very legitimate based on the United States constitutional tradition of how the Constitution was passed, eventually amended, right? The various rights and freedoms are the amendments to the Constitution, still over 100 years ago. Right? Based on this tradition, very legitimate debate, but not one that we have in Canada, because we don't just have more progressive rights and freedoms, we also have more progressive canons of interpretation which are, right, constitutionalized, which are not contested. No one has contested the Living Tree Doctrine after 1929, right? Certainly today it is not contested by any member of the Supreme Court in its substance, right? I mean, it's more specific application in some cases, but not in its substance. And no one has really contested that paradigm of substantive equality. We saw from 1982, right, which is not something most judges of the Supreme Court would adhere to, right? This paradigm of substantive equality has been reiterated by a unanimous Supreme Court of Canada over and over and over again after 1982, with basically no exceptions. So this is interesting, right? And the case itself, if I've convinced you yet to go beyond the syllabus, you probably should. The case itself is very interesting because we see that discussion, the tension, that role of the judiciary, and also, right, important stuff, right? That's what the law is about. That's what makes it a noble purpose in the human experience, right? We see these social debates happening through the law, and whether or not you think that should have been settled through the Constitution, it happened through the law. It happened through people debating, through people suing, through people, making their way through the legislative process and convincing people, right? And even the dissenting judges agree on that. Convincing people that their position is correct. And we see in the law, right, these very important social debates happen, and we also see, one way or the other, right, with messy disagreement, including at the United States Supreme Court, right, with half the judges thinking the majority is dead wrong, right, using language that's very far from the concluding sentence, I respectfully dissent. Even with that messy process, we do see the evolution of a society, right? We see rights being recognized. We see people no longer being able to be owned. We see women gaining rights, gaining, right, prominence in society, gaining the ability to be part of the conversation. And arguably that struggle, right, is still ongoing today. And we see that certainly in that case, right, at least as much as we see it in Canadian constitutional law. So what happens in the case, right, very briefly, again, most of the important stuff is a comparative insights that we can glean, and lots of that might be left to you if you read the entire decision, right? So, contrary to Canada, right, where we had the government pass a law that said, right, marriage is not restricted to a man and a woman, right? So obviously, the Supreme Court was opining on something much less controversial there, not someone contesting the definition of marriage, but rather the government just trying to do the opposite. So here we have, right, something different. People basically ask for the right to marry, and they also ask for the right for that marriage to be recognized in various states. And you see marriage here, as I said, as a civil institution. This is not about saying, I want the Catholic Church to marry me, right? Because that involves equally important and more important, not by virtue of me saying it, by virtue of the Constitution saying it, right? More important concerns of freedom of religion, especially in the United States. So the Catholic Church, by virtue of that freedom, doesn't have to let you in, right? Doesn't have to have you be a member. Even if you believe in Jesus Christ and you think you're going to go to hell if you're not a member of the Catholic Church doesn't have to have you as a member, much less does it have to marry you. This is about civil marriage. This is about the law saying, regardless of whether you got married in the Catholic Church, right, in Buddhist temple or the courthouse, it can be between a man. It can be between anything but a man and a woman. And of course, we see this interplay of social issues because the law in the first place has recognized a religious institution, right? And that's why it still has a religious underpinning, even though strictly speaking from a legal standpoint, it's just a form of legal ordering, right? Which creates relationships between people and subsequently consequences upon the breakdown of the marriage or otherwise, right? And so these people are generally, right, denied benefits. They're denied benefits when they die, right? Survivors' pensions, intestate succession, all sorts of things that you don't think about, right? Substitute decision making when you're sick, right? The ability to to not have to testify in court against your spouse, all sorts of things which are enshrined into the law and which, as a result of this, right, same-sex couples don't have access to. And the Supreme Court, the majority, is going to go further and say, this is also about dignity. This is about not being a lesser member of, right, society. And you see, I think it's Justice Roberts, Chief Justice Roberts, right, making a pretty compelling argument that that might be extended very shortly to multiple spouses, more than two, and that there is no reason why that argument naturally can't be extended there, and in fact might be more easily extended there. And so they ask for the recognition of marriage, and they don't get it. And the court goes through this and says this is about, right, their fundamental dignity, their ability to be part of society, gain access to these benefits, but also be recognized as a couple and be able to build that, because marriage is, right, certainly to the more right-leaning people, the foundation of society, right, the foundation of the family. So there's children, so there's survival of the race, and so there's ordering in that family unit being significant. But certainly to the majority as well, right, an ability to gain this sense of intimacy, the sense of, right, companionship, the sense that really it's a fundamental ordering aspect of society, such that you might not get as much from life, or you might not get everything you can get from life unless you have access to it. And the court rightly says, like other institutions, it is subject to change, and it has changed significantly. The majority is going to give the example of various groups of people, including interracial marriages, right, being denied the right to get married. Also mentions the fact that up until very, very recently, several decades ago, right, women couldn't own stuff except through their husbands simply because they weren't, right, they didn't have the legal capacity to do that. And in that sense, we might see again, right, what I've discussed as critical race theory, right, this similar to critical race theory, right, this idea that the law creates and preserves existing power dynamics, right? The reason why women couldn't hold stuff is not because they couldn't, right? It's because the law said they couldn't. And in that sense, right, dismantling that barrier, right, might make the law something else than an objective fact. The fact that we have to dismantle that barrier. Court discusses public attitudes, right? Majority says this has been debated quite a bit. But significantly, the majority is going to constitutionalize the issue, right? And we see that in Canada as well. The Constitution isn't there for judges to say this isn't fair, this is a bad law, this is a bad idea. The Constitution is there to say, regardless of what happens, regardless of the fact that the majority agrees, regardless of the fact that we think it's good or bad law, there's certain things we just don't tolerate. And that includes taking rights away from people, and often in an unfair manner. And so in Canada, right, that Section 15 expands that, expands the things that governments can't do. Even if they have, right, a majority, even if everyone supports them, right, they can't go after historically disadvantaged groups. And court frames that as well as a choice, right, a fundamental choice in a person's life, and the lack of access to that choice being, right, somehow not legitimate. And the court is going to, the majority is going to allude very, very interestingly to that sense of family, but in a more progressive way, right? So it's going to challenge that kind of more conservative view of the family unit as fundamental to society, but as being ordered by a more traditional conception of marriage. And arguably, if you read the dissents, which, again, I strongly encourage you to, right, you see that the dissenting judges are going to say this is not supported by precedent, not supported by existing legal constitutional doctrine in the United States, but significantly that it's not a legal argument, right, that the court is imposing its policy preferences upon the entire society, right, and in a way that's, right, made in a rhetorical sense, right? Rhetorical means you're arguing things, but not, right, arguing things nicely, but not supported necessarily by fact or law. And of course, there's this denial of benefits, right? The dissenting judges are going to say, due process is about we don't take away your liberty. It's not about getting benefits. But the majority is going to adopt a definition, arguably not right consistent with the text of the provision itself, contrary to Canada, right? Canada specifically says you have the right to benefits in some circumstances, right? And the majority is going to say that it's a denial of benefits, right, for same-sex couples. And in framing that issue, right, the majority, again, I've mentioned this, agrees that there's been some public debate on this issue, but says, right, again, this is a constitutional issue. This is about the right of minorities. It's about whether we can infringe upon these rights. And in that sense, that issue is not subject to democratic choice, regardless of, right, what the majority thinks. And there's the same exception for freedom of religion, right? First Amendment ensures that religions, right, are able to live according to their faith. So this is about you getting access to marriage in the courthouse if no one wants to marry you. And the First Amendment, right, Section 2 in Canada, is going to protect that ability of people to have religious objections, whether they are to, right, the solemnization of marriage or the recognition of marriage within their religion. And so that's it, really. I don't want to spend too long on this, but this opinion is interesting for the comparative insights, and certainly you should at least read the majority opinion. But I think the dissenting opinions really give you a better sense of the issues that are at play, and that might have been, right, ignored or brushed away by the majority, and according to the dissent, to make a decision that, right, it favors politically or personally.